First thing I want to do, Last Cancorla, is I want to commend Ministers Rabbitte and O'Gorman for bringing forward this very important piece of legislation. Being frank, and I'm sure they would agree with this, it's embarrassing that in Ireland today people still have to make applications under what's referred to as the Lunacy Regulation Ireland Act 1871. That's a piece of legislation, as Deputy Berry indicated a few moments ago, is 150 years old. Notwithstanding that, and notwithstanding the archaic language within that legislation, people still have to go through that procedure at present if they find themselves in the situation where a loved one or a close member of their family requires protection through an application under the wardship system. Obviously, every person who is aware of this issue or who is interested in this issue should have at the forefront of their mind that if there's somebody close to them and who, because we now live in a much healthier society, is necessarily living longer, it's important that we prepare for their lengthier lives. Obviously, the most important thing to do is to try to ensure that those individuals, before they lose capacity, before they get too elderly, that they put in place a power of attorney, so that if they lose their capacity, they are able to ensure that persons close to them or persons that they trust are in a position to make important decisions on their behalf for the remaining years of their life. Unfortunately, on very many occasions, Last Cancorla, that isn't done. And as a result of that, family members find themselves in a situation where they can't gain access to a mother or a grandmother's bank account in order to pay for the upkeep of that mother or grandmother, and they can't make any decisions in respect of the care or medical treatment of that elderly person because they don't have the appropriate legal responsibility for the person. If they do find themselves in that unfortunate position and they don't have a power of attorney, the only option available for them then is to go through the lengthy, the costly and the unfortunately necessary process of making an application to the High Court seeking to have the person who has lacked capacity to be made a ward of court. So this legislation is very welcome, that we're going to go away from that old archaic system. I'm conscious under the legislation that was enacted in 2015, some 7 years ago, but which hasn't been commenced, that there's going to have to be a large number of applications made to the court in respect of those people who are at present under the wardship system. Under Section 54 of the 2015 Assisted Decision-Making Capacity Act, which has not yet been commenced, there's a requirement that the wardship court shall, within 3 years from the date of commencement of that part of the Act, make a declaration under Section 55(1) in respect of a ward who is 18 years or older by that date. Now, Ministers, I'm sure you're aware that that's going to give rise to a significant amount of work in the courts, predominantly within the High Court. I don't have exact numbers in terms of how many wardships we have at present, but I know from work I did on the Justice Committee in the previous stall that as of 2015 there was approximately 2,000 wards in Ireland, and I know that since the enactment of the 2015 legislation that there's been approximately over 2,000 more. Now, obviously some of those individuals will have died and the numbers won't be at that full level, but it certainly is the case that there's going to be a very large number of applications that will have to be made under Section 54 of the 2015 Act when it comes into operation through its commencement. I suppose the issue that you need to take into account, Ministers, is how you're going to deal with that. The courts need resources in order to ensure that these important applications that require very significant evidence to be put before the court are considered carefully by the court. So I would ask you to engage maybe with the Attorney General to determine how are those lists going to be dealt with, because they're necessarily going to take up a huge amount of court time. That's not the primary issue. The primary issue is that the people whose applications are being made, or on behalf of whom applications are being made, they need to have those applications dealt promptly. And the last thing we want to hear is that they're being delayed because of delays in the court system. Like at present, it is an unusual application that people still have to go through. They have to get affidavit evidence. It's an application that's made to the President of the High Court, and it is a very confusing system for the families that are making the application, because it's something that is alien to them and they don't feel they have an understanding of it. I suppose one of the trends of modern legislation is that we delegate away from the courts issues in respect of decision-making matters that the courts previously held. I think it's welcome that ultimately we're going to have this statutory body that has been set up under the 2015 Act that will make important decisions on behalf of people who lack capacity. I also welcome the other aspects of the legislation which are for the purpose of ensuring that the rights of people with disabilities are fully recognised. You'll note, and I know you ministers have added on to this legislation, the fact that now, when it comes to the selection of jurors under the Juries Act, that people will be able to play their role on juries, notwithstanding the fact that they are deaf. But if they're able to comprehend evidence that's going on with the assistance of a person who is proficient in sign language, well then there's no reason why that person should not be entitled to serve their civic function by being a member of the jury. I'm also conscious that the legislation seeks to repeal section, I think it is 41 of the 1992 Electoral Act, which removes the bar on a person of unsound mind being a member of Dáil Éireann. I suppose the importance of that is that it takes away language which, although not as archaic as the 19th century language of the lunatic, is still language that I think isn't appropriate to have on our statute book. In terms of people of unsound mind, I think we have to move ourselves away from such judgment-heavy language. So listen, I commend both ministers in respect of the legislation. I think it is important that we and you try to bring the energy to this legislation that you've brought to date. It is unacceptable, not simply that the 1871 legislation is still in place in terms of section 15 of it, but the fact that the Houses of the Oireachtas enacted legislation in 2015. You know, we should not have to wait for a period of 7 years before legislation is commenced. I'm conscious that because of the delay, there's now a requirement to amend parts of that legislation from 2015. But I would urge you to ensure that you can get this before committee as quickly as possible, and at the same time, if you can try to ensure that when we do get it enacted and commenced, that we're going to have an efficient system of having those applications dealt with by the court. Thanks very much, Laskin Corla.